I want you to imagine something for a second. Put yourself in the shoes of a project director.
Oh, man. That is a highly stressful place to be right off the bat.
Right. It really is.
Yeah.
So you have just survived what can only be described as a grueling, just a soul-crushing, multi-year dispute on a massive international construction mega project.
We are talking half a decade of your life just gone.
Exactly. Gone. Years of late nights, tens of millions of dollars burned in legal fees, millions of emails being cataloged and analyzed by aggressive lawyers.
Plus the endless technical expert reports trying to figure out, why the concrete cracked or why the steel was delayed.
Yeah, just a mountain of sheer, unadulterated stress. And then finally the day comes. The Arbitral Tribunal issues their final award.
The moment of truth.
Right. You open the PDF, you scroll to the very bottom, and you won.
Best feeling in the world.
You are awarded $50 million. You take a breath, you pump the champagne, you feel completely, utterly vindicated. But then, the hangover hits.
Yeah.
Because you suddenly look at that piece of paper and realize something actually pretty terrifying.
Yeah, the losing party, the company that now owes you that $50 million, is located in a completely different sovereign country.
And that is the absolute nightmare scenario because their assets, their bank accounts, their shiny corporate headquarters, all their heavy machinery, they are all locked securely behind a foreign legal system, thousands of miles away.
Totally out of your immediate reach.
Right. They operate in a different language, under a completely different set of laws, with local judges who might actually be very sympathetic to a hometown company. So you hold a piece of paper that says you're a multimillionaire. But how do you actually reach across borders and force a foreign bank to hand over that cash?
It's the ultimate vulnerability for anyone doing cross-border business, really. I mean, you can spend millions to win the theoretical battle in an arbitration room in London or Paris, and then completely lose the actual war at a bank branch in another hemisphere.
Yeah, the victory is entirely hollow if the enforcement mechanism fails.
Exactly. It's just a piece of paper.
So to figure out how you actually get your money out of this nightmare scenario, we've spent the week tearing through a mountain of data for our deep dive today. We are looking at the original 1958 treaty text that basically governed global trade, massive empirical data sets on why these construction projects fail in regions like the Gulf Cooperation Council, and some absolutely brutal legal analyses of modern, heavily weaponized contracts.
Yeah, there's a lot to unpack here.
There really is. We're going to break down the mechanics of international arbitration and explore the frankly harsh realities of how legal risk is just dumped onto contractors. So whether you are a claims specialist buried in spreadsheets, a commercial director trying to keep a billion-dollar development afloat, or just someone fascinated by how global mega projects don't just, collapse into anarchy, this masterclass is for you.
Because this intersection where pristine international treaty law meets the muddy, chaotic trenches of construction project management, that's where global fortunes are literally made and lost.
It really is. So let's start with the safety net, because before we can talk about how disputes are fought in the dirt and the concrete of a construction site, before we even look at a contract or a schedule, we have to understand the fundamental architecture that makes any of this possible.
Right, the bedrock.
Yeah. Without a specific legal mechanism, international arbitration is essentially just a very expensive gentleman's agreement. You have a private arbitrator say, hey, you owe this guy money, and the losing party could just laugh, say, make me, and walk away.
And historically, they did.
Right. So that mechanism that stops them is the 1958 Convention on the Recognition and Enforcement of Foreign Arbitral Awards, universally known as the New York Convention.
It is, and I don't say this lightly, it's no exaggeration to call it the most successful instrument of international commercial law in human history.
Wow. In human history.
Honestly, yes. I mean, we take for granted today that a structural engineering firm in Germany can sign a contract with a developer in Saudi Arabia, build a massive infrastructure project in the UAE, and have any resulting disputes resolved privately in London.
No logistical miracle when you think about it.
It is. And that entire ecosystem, the trillions of dollars flowing through it, relies on a singular foundational premise: that the final decision rendered in London will actually be respected and enforced by the authorities in Saudi Arabia, Germany, or the UAE.
I tend to look at the New York Convention as like a universal diplomatic passport for legal victories. If you hold a valid arbitral award, this convention acts as the passport that allows that award to cross sovereign borders, walk past the customs agents, and be recognized by a foreign judge as if it were one of their own domestic judgments.
That's a really great analogy.
But to appreciate how powerful this passport is, we kind of need to understand the dark ages of international trade. Take us back to before 1958. How did companies actually resolve cross-border disputes back then?
Oh, it was a labyrinth of inefficiency. You really have to look at the post-World War II economic boom. You had this massive explosion in international trade, supply chains were suddenly going global, but the legal mechanisms to resolve disputes were stuck in the 19th century.
They just hadn't caught up.
Not at all. There were older treaties, most notably the 1927 Geneva Convention, but they were incredibly cumbersome because they were totally obsessed with state sovereignty.
Sovereignty meaning countries were terrified of letting a private foreign arbitrator dictate what happens inside their borders.
No. Exactly. The old system demanded what was known as double exequatur, or double finality.
Double finality.
Okay, how did that work?
Well, under that regime, if you won an arbitration in, say, Switzerland, and you wanted to enforce it against assets in Italy, you couldn't just go to Italy. First, you had to fight a whole legal battle in the Swiss courts just to prove the award was final and binding under Swiss law.
So you need permission from the place you started in.
Right. You had to get a specific judicial certificate of finality. Then, you took that certificate, traveled to Italy, and fought a second full legal battle in the Italian courts to get them to recognize the Swiss certificate and actually enforce the award.
That sounds like a lawyer's dream and a business person's absolute nightmare. I mean, you are doubling the litigation just to enforce an arbitration that you originally chose specifically to avoid litigation in the first place.
It completely defeated the commercial purpose of arbitration, which is supposed to be efficient, neutral, and binding.
The international business community realized this double hurdle was actively stifling global trade. Companies were refusing to do business in certain countries because they knew if things went south, they could never collect on a debt.
So the risk was just too high.
Way too high. They needed a system where an award rendered in one country would be readily, almost automatically, enforceable in another without having to ask the first country's courts for permission.
So the international community convenes this massive conference in New York in 1958. They sit down to draft a new treaty. And the success of this document is just staggering. We are currently looking at over 172 contracting states.
It's virtually the entire civilized world.
That is almost the entire globe agreeing on a single legal standard for debt collection. But, just like the passport, it dictates exactly which borders you can cross and under what specific conditions. So let's look at the mechanics, starting with Article 1. This kind of sets the boundary lines for what the treaty actually covers.
Right. Article 1 defines the scope. The fundamental rule is that the convention applies to the recognition and enforcement of arbitral awards made in the territory of a state other than the state where the recognition and enforcement are sought.
So it's explicitly designed for foreign awards. If two French companies arbitrate in Paris and they try to enforce that award against a bank account in Paris, this convention doesn't apply at all. They just use domestic French law.
Exactly. It's an internal matter.
But if they arbitrate in Paris and the loser's money is sitting in a bank in New York, boom, the convention activates.
That is the standard application. But Article A also includes this really fascinating, highly pragmatic addition. It states that the convention also applies to arbitral awards not considered as domestic awards in the state where enforcement is sought. This creates a safety net for what we call non-domestic awards.
Okay, that sounds a bit like a legal riddle. How can an award be physically handed down inside your own country, but you don't consider it a domestic award?
It accommodates the sheer complexity of international contracts. Let's say you have a massive infrastructure project. The arbitration physically takes place in Frankfurt, Germany. But the parties are from different countries, and in their contract, they specifically agreed to use the procedural arbitration laws of Switzerland, perhaps because they preferred Swiss confidentiality rules.
Oh, I see. So the location is German, but the flavor is Swiss.
Right. So because of that strong foreign procedural element, a German court might look at the final award and say, well, it happened in Frankfurt, sure, but you use Swiss rules, so we don't recognize this as a purely German domestic award under our civil code.
It's a hybrid.
Yeah. And the New York Convention anticipates this exact scenario. It steps in and says, that's fine. If Germany considers it non-domestic, the convention still applies to protect it and enforce it. It basically prevents highly complex international awards from falling into a legal void where neither country claims them.
It's catching the edge cases so nobody falls through the cracks. Now, when a country signs this treaty, they don't just surrender their sovereignty unconditionally, do they? I know Article I allows states to make certain declarations or reservations, when they sign up. They can kind of put a fence around how much of the treaty they accept.
Yes, there are two primary reservations states can utilize. First is the reciprocity reservation. A state can declare that it will only apply the convention to awards made in the territory of another contracting state.
So, if you are foolish enough to base your arbitration in a country that hasn't signed the convention, and then you try to enforce that award in a country that has signed it, and that country made the reciprocity reservation, they can just turn you away at the door.
They absolutely can. Though, as you pointed out, with 172 member states, finding a non-member state is becoming incredibly difficult. It's mostly isolated nations or microstates at this point. The global economy has essentially forced everyone to join the club.
Right. You can't really do international business if you're not in the club. And what about the second reservation?
That's the commercial reservation. A state can declare it will only apply the convention to differences arising out of legal relationships that are considered commercial under their own national law.
What's the point of that?
Well, the drafters in 1958 wanted to assure skeptical governments that this powerful treaty wouldn't be used for, family law disputes, inheritance battles, or certain types of purely domestic real estate issues. It is strictly a tool for commerce.
Okay, so that establishes the jurisdiction. We know when the passport is valid. But before you even get to an award, before you even start an arbitration, you have to prove that the parties actually agreed to arbitrate in the first place.
The foundational agreement.
Right. And this brings us to Article 2, which I find genuinely fascinating because it highlights the tension between ancient law and modern technology.
Well, Article 2 is the gateway. It obliges all contracting states to recognize an agreement in writing under which the parties undertake to submit their disputes to arbitration.
Which is huge.
It is incredibly powerful. It means if you have a valid arbitration clause in your contract and the other party tries to bypass it by suing you in their local court, which happens all the time, you can walk into that court, waive the written agreement at the judge, and Article 2 legally requires the judge to halt the litigation and mandate the parties go to arbitration.
Unless, of course, the agreement is null and void, inoperative, or incapable of being performed, like if it was signed at gunpoint or something.
Oh, obviously.
But the phrase "in writing" is the sticking point here. This treaty was written in 1958. We are basing the multi-trillion-dollar modern global economy on a document drafted when computers took up entire rooms. What did "in writing" legally mean to the plenipotentiaries in 1958?
The 1958 text is quite explicit. It defines an agreement in writing as an arbitral clause in a contract signed by the parties, or contained in an exchange of letters or telegrams.
Telegrams. The foundation of modern international dispute resolution explicitly relies on telegrams. That is wild to think about.
It's hilarious, but it perfectly illustrates the challenge of a static treaty surviving through a massive technological revolution. And for decades, this caused serious, highly expensive legal headaches.
I can imagine.
Fast forward to the late 90s and early 2000s. What happens when two massive corporations agree to a billion-dollar joint venture and the agreement to arbitrate is contained in a chain of emails, or via electronic data interchange systems used in logistics, or, a click-wrap agreement on a cloud software platform?
Let me guess.
Yeah.
You had strict textualist judges in certain national courts looking at the original 1958 text and saying, an email is demonstrably not a telegram, and it is not a physically signed piece of paper with wet ink. Therefore, this arbitration agreement does not exist.
That is exactly what happened in several jurisdictions. Parties were escaping valid arbitration agreements on technological technicalities. It was actively threatening to destabilize modern trade.
So how do you fix that? You can't just call 172 countries back to New York and ask them to ratify a brand new treaty.
Yeah.
That would take half a century and billions of dollars in diplomatic capital.
No, you definitely can't. So the international community used a very elegant, pragmatic workaround. In 2006, major international trade law bodies issued a formal, globally recognized recommendation.
What did it say?
They basically acknowledged that the strict reading of the 1958 text was causing divergent and harmful interpretations. So they explicitly recommended that Article 2, Paragraph 2 be applied, recognizing that the circumstances described letters and telegrams are explicitly not exhaustive.
So they essentially issued a highly authoritative software patch for the treaty. They provided an official interpretation guide that said, listen, we all know the text says telegrams, but the spirit of the text means any recorded communication. Read it broadly to include all forms of modern electronic commerce.
That is a perfect way to describe it. They tied the interpretation to modern instruments governing electronic commerce, validating emails, digital signatures, and electronic data records. It demonstrated how the convention functions as a living document. It breathes and adapts to current commercial practices through interpretive consensus without needing a single word of its foundational text rewritten.
It's an incredible piece of legal architecture. And speaking of how this convention interacts with local laws, we have to talk about Article 7.
Yeah.
Because this is the part that proves the convention isn't trying to act like a global dictator. It's actually trying to be a supreme facilitator.
Article 7 is universally known as the more favorable right provision. It states that the New York Convention does not deprive any interested party of any right they may have to avail themselves of an arbitral award in the manner and to the extent allowed by the law or the treaties of the country where the award is sought to be relied upon.
Okay, so translate that into a practical scenario for me. Let's say I'm trying to enforce an award in France. I have my New York Convention passport ready, but I look at French domestic law, and I realize that the French system is actually incredibly pro-arbitration. Their domestic laws make it even faster and easier for me to seize the losing party's assets than the rules in the convention itself. Can I just ignore the treaty and use the local French law?
You absolutely can, and the convention actively encourages you to do so. The New York Convention sets a floor for enforcement, not a ceiling.
A floor, not a ceiling. I'll agree.
Exactly. It guarantees a minimum baseline standard of global enforcement that no member state can drop below. But if a highly progressive jurisdiction like France or Switzerland wants to enact domestic legislation that removes even more barriers, the convention explicitly steps aside and says, use their rules. The ultimate goal is the enforcement of the award by whatever valid legal path offers the least resistance.
So we have the baseline. We've got our diplomatic passport. We've established that the agreement is valid, even if it was signed via a frantic email chain, thanks to the 2006 interpretive guidance.
Right.
And we know we are guaranteed at least a minimum standard of global treatment.
Right.
But theory is cheap. When I actually show up at a foreign court demanding $50 million, that company is not going to just hand over the keys to their vault. They're going to fight me tooth and nail. They're going to hire a small army of expensive local lawyers to find any loophole, any procedural error, any excuse to stop me from cashing in. How does that enforcement actually play out in front of a judge?
This is where we get into the teeth of the treaty, how the enforcement is initiated, and crucially, the very narrow pathways a losing party has to challenge it. Let's start with the initiation phase. According to the text, Articles 3 and 4 dictate the rules of engagement. And structurally, it is designed to be astonishingly simple.
How simple?
Well, Article 3 mandates that contracting states shall recognize awards as binding and enforce them. Furthermore, it explicitly prohibits states from imposing substantially more onerous conditions or higher fees on foreign awards than they impose on their own domestic awards.
So there is an absolute ironclad prohibition on discriminatory protectionism. No home field advantage allowed.
Exactly. And Article 4 tells you exactly what you need to bring to the courthouse to trigger this enforcement. You really only supply two things: the duly authenticated original award, or a certified copy, and the original arbitration agreement in writing, or a certified copy. And if those documents aren't in the language of the local court, you bring a certified translation.
Wait, is that genuinely it? Just two documents and a translation to claim $50 million?
That is the genius of the streamlined process. The enforcing court is not an appellate court. You do not have to relitigate the facts of the case.
Right, you're not starting over.
Exactly. You don't have to fly in structural engineers to explain the nuances of concrete curing times to a local judge who has zero background in construction. You bring the contract, you bring the award. You say, we legally agreed to arbitrate. The independent arbitrator made a decision. Here's the result. Please attach their assets. It is designed to be a highly efficient summary proceeding.
Okay, I have to play devil's advocate here. I imagine a desperate losing party standing in that courtroom. If the process is really this streamlined, how do they defend themselves? What if the losing party genuinely believes the arbitrator was utterly corrupt? Or what if they claim they never even signed that contract in the first place? Does a local court have the power to look at those two pieces of paper and say, no, something is wrong here?
Absolutely. The convention is a powerful tool for commerce, but it is not a blank check for tyranny. It recognizes that fundamental due process and fairness must be protected, otherwise the entire system loses legitimacy. This brings us to the absolute battleground of international arbitration, Article V.
Ah, these are the limited grounds for refusal.
Yes. Article V lists the exact, exhaustive, and strictly limited grounds upon which a court may refuse to recognize and enforce an award, and it is vital to understand that the burden of proof is entirely reversed.
Meaning the winner doesn't have to prove it's valid.
Correct. The winning party doesn't have to prove the award is fair. The award is presumed valid. The party resisting enforcement has the heavy burden to furnish concrete proof of one of these specific defenses.
I want to dig into these defenses because this is where the millions of dollars in legal fees are spent.
Yeah.
If I'm trying to block an award, what is the very first argument I'm going to make?
The first line of defense is found in Article V, paragraph 1A, incapacity of the parties or an invalid arbitration agreement.
Meaning I couldn't legally sign the contract in the first place.
Correct. The most common scenario involves state-owned entities. Imagine a scenario where a foreign government ministry signs a massive infrastructure contract that includes an arbitration clause. But under that specific country's constitutional law, government ministries are strictly forbidden from submitting to private international arbitration without the explicit written approval of the Minister of Finance.
And they just skip that step.
Right. If they never got that approval, the entity lacked the legal capacity to enter the agreement. Or perhaps the agreement itself is invalid under its governing law due to fraud or duress. If there is no valid foundational agreement to arbitrate, the arbitrator never had any legal power over the parties.
That makes total sense. You can't be bound by a private judge if you never legally consented to their jurisdiction.
Yeah.
But let's say the contract is rock solid, the signatures are perfectly valid. What's the next angle of attack?
Then you move to Article V1B. This is the fundamental due process defense. A court can refuse enforcement if the party against whom the award is invoked was not given proper notice of the appointment of the arbitrator or of the proceedings, or was otherwise unable to present their case.
So an ambush. If I'm the winning party and I essentially conduct a secret shadow arbitration in a hotel room in Geneva, don't tell the other side it's happening and just show up in their home country a year later with a ruling demanding payment, the court will throw it out.
Precisely. Arbitration fundamentally relies on the adversarial process. Both sides must have a fair, equal opportunity to be heard. If you are denied that opportunity, the resulting award is hopelessly tainted.
But the phrase unable to present their case feels like it could cover a massive amount of ground. What if we were having a legitimate arbitration, but my star technical witness, the only engineer who understands why the foundation cracked, is unexpectedly denied a travel visa to attend the final hearing? And the arbitrator just refuses to delay the hearing, we lose, and I argue I was unable to present my case. Does that count?
It absolutely might. And that is exactly the kind of highly complex factual matrix that lawyers will litigate for years. Local courts have to carefully evaluate if it was just a minor procedural hiccup or a severe fundamental violation of due process. Did the tribunal offer alternatives, like a video link for the witness? If the tribunal was wholly unreasonable and it materially affected the outcome, the award can be refused.
Let's keep exploring these defenses. I keep thinking about the actual hearing itself. What if the arbitrator just goes completely rogue? Like, we hired a tribunal to figure out a specific delay involving concrete pouring, and suddenly they start issuing financial penalties regarding the intellectual property of the software running the plant. Is there a defense against an overreaching arbitrator?
Yes, that brings up another core defense, Article V1C. The award deals with a difference not contemplated by or not falling within the terms of the submission to arbitration. In legal terms, we call this the ultra vires defense, or excessive authority. Exactly. The arbitrator is not a king. Their power is strictly confined within the boundaries of the specific dispute the parties submitted to them. If you only submitted a dispute about concrete and they award damages for software, they have stepped outside their designated boundary.
And if they do that, does the entire $50 million award get thrown in the trash just because they overstepped on one issue?
Not necessarily. The convention is highly pragmatic here, too. It specifically notes the concept of severability. If the valid parts of the award, the decisions on the concrete, can be clearly separated from the bad parts, the software decision the enforcing court can uphold and enforce the valid decisions and simply refuse to enforce the ultra vires portion.
It surgically removes the bad part to save the core award. Okay, what about the people actually making the decision? Does it matter who is sitting on the tribunal?
Immensely. That is covered by Article V1. Enforcement can be refused if the composition of the arbitral authority or the arbitral procedure was not in accordance with the explicit agreement of the parties.
Give me a real-world example of how that goes wrong.
Let's say your highly specialized contract explicitly dictates: disputes shall be resolved by a panel of 3 arbitrators, all of whom must be qualified civil engineers with at least 20 years of experience in tunneling. But when the dispute arises, the arbitral institution accidentally appoints a single retired maritime judge who has never seen a tunnel in his life.
The procedure violated the foundational agreement.
Exactly. The parties are the ultimate masters of the arbitration process. They dictate the rules of the game. If the tribunal or the administering institution ignores the parties' bespoke agreed-upon rules, the resulting award is structurally defective and highly vulnerable at the enforcement stage.
And that leads us to the final defense that a losing party can actively raise. What is the ultimate kill switch for an arbitral award?
Article V1. The award has not yet become binding on the parties, or, and this is the critical part, has been set aside or suspended by a competent authority of the country in which, or under the law of which, that award was made.
Okay, so let's trace this out. We arbitrate in London. The tribunal awards me $50 million. Before I can fly to New York to seize your assets, you go to the English High Court, the court at the seat of the arbitration, and you successfully argue that the arbitrator took a massive bribe. The English judge annuls the award. It is officially set aside. I can't just take that annulled piece of paper to New York and try to enforce it anyway, right? The award is dead at the source.
Generally speaking, yes. The seat of the arbitration has primary supervisory jurisdiction. If the courts at the seat annul the award, it ceases to exist legally. Trying to enforce an annulled award is like trying to use a revoked passport.
That makes sense.
However, remembering our earlier discussion about Article 7, the more favorable right provision there is a very advanced, highly controversial nuance here. Certain progressive jurisdictions, most notably France, have occasionally enforced awards even after they were set aside in their home seat.
Wait, really? How is that possible?
The French legal philosophy views an international arbitral award as a transnational decision of international justice, not strictly tethered to the domestic law of wherever the hearing happened to physically take place. But that is incredibly complex legal territory. For the vast majority of cases, having the award set aside at the seat is a primary, highly effective defense against global enforcement.
So those are the 5 defenses the losing party can actively raise and try to prove. But looking at the texts, there are 2 additional grounds where the court can refuse enforcement on its own motion, meaning even if the losing party is asleep at the wheel and doesn't bring it up, the local judge can look at the file, raise their hand, and say, no, I'm stopping this to protect my own country. What are those?
These are found in Article V, Paragraph 2, and they are designed to protect the sovereign interests of the enforcing state. The first is arbitrability. The court finds that the subject matter of the difference is simply not capable of settlement by arbitration under the law of that specific country.
What kind of subject matter is off limits to private arbitrators?
Usually matters that deeply involve core state interests, public welfare, or highly vulnerable parties. For example, criminal matters are universally non-arbitrable. You cannot privately agree to arbitrate a murder charge.
Heck, obviously.
In many jurisdictions, antitrust or anti-competition law violations, insolvency proceedings, or certain domestic employment and consumer protection disputes are ring-fenced. If a private arbitrator tries to dissolve a bankrupt company or strip a consumer of their statutory rights, a local judge will intervene. They will say, private citizens do not have the power to adjudicate these issues under our laws, only the sovereign state does, and enforcement will be refused.
You can't privately contract your way around the criminal code or bankruptcy laws. That makes perfect sense. And what is the final ground?
It is the most famous, the most heavily debated, and perhaps the most mysterious defense in international law: public policy. The court can refuse enforcement if it would be contrary to the public policy of that country.
That sounds like a massive, gaping loophole. I mean, public policy could mean literally anything. If I'm a local judge and I really want to protect a massive local employer from paying a foreign contractor because it might cause local layoffs, can I just wave my hands and say, enforcing this award would hurt our local economy, therefore it violates our public policy? Case dismissed.
If national courts did that routinely, the entire New York Convention would collapse overnight. The system only survives because courts globally have agreed to interpret the public policy exception incredibly narrowly.
How narrow are we talking? Give me the threshold.
We're talking about international public policy, not just minor domestic regulatory quirks or economic protectionism. To violate public policy, the award must offend the most basic fundamental notions of morality and justice in that forum.
The classic examples involve extreme corruption. If a tribunal enforces a contract that was demonstrably secured by bribing a government minister, the enforcing court will say, we will not use the power of the state to enforce the fruits of bribery. That violates our fundamental moral code. It also covers awards that compel a party to commit an illegal act, like drug trafficking or terrorism financing.
So it really has to be egregious.
It is a remarkably high bar. It is explicitly not enough that the local judge would have simply decided the case differently or that the underlying contract violates some minor local administrative statute. It has to be utterly repugnant to fundamental justice. The standard response of most courts is a strong pro-enforcement bias.
Okay, this paints an incredibly clear picture. The New York Convention is the bedrock. It guarantees that if you win a valid arbitration, you have a universally recognized mechanism to enforce it, and the defenses against it are strictly limited and heavily burdened. It's a staggering achievement in international law.
It really is.
But here is the reality check. Absolutely nobody actually wants to go to arbitration in the first place.
No, it's a nightmare.
It is a failure state. It is a last resort after everything else is burned down. So we have to pivot our focus. What are these massive, sophisticated companies actually fighting over that leads them to invoke this international treaty? We need to move from the macro level of sovereign international law down into the microscopic, granular level of project contracts.
And this is where the pristine, elegant theory of international arbitration crashes headfirst into the very messy, combative reality of the global construction industry. Because these multi-million-dollar disputes don't magically appear in a courtroom, they are seated in the contract documents signed years earlier.
The data we've been analyzing gives us a deep look at how this plays out, specifically focusing on international megaprojects with a real spotlight on regions experiencing massive infrastructure booms, like the Gulf Cooperation Council or GCC region, places like the UAE, Saudi Arabia, and Qatar. To understand this battlefield, we have to start with the weapons they are using, and the foundational architecture for almost all of these projects is the standard form engineering contract. The biggest name in this space is FIDIC.
Yes, FAEE, the International Federation of Consulting Engineers. They publish internationally recognized standard form contracts, like the famous Red Book for Construction or the Yellow Book for Plant and Design Build. These templates are the default starting point for major infrastructure projects globally.
What is the underlying philosophy of these standard forms? Why did the engineering industry spend decades creating these massive standardized rulebooks?
The original philosophy of these standard forms is brilliantly pragmatic. It revolves around the concept of equitable, balanced risk allocation.
Equitable meaning fair.
Right. The guiding principle is simple but economically profound. You must assign a specific project risk to the party that is in the best position to control it, manage it, foresee it, or insure against it.
Walk me through how that works in practice. How does risk allocation affect the price of a project?
Let's take one of the biggest variables in construction, unforeseen ground conditions. Imagine you are hired to build a massive subway tunnel. You study the geological surveys provided by the employer, and it looks like standard soil. You start digging, and a month in, your tunnel boring machine hits a massive uncharted vein of solid granite.
Oh, wow.
That is a catastrophic risk. It will delay the project by 6 months and cost tens of millions of dollars in specialized drilling equipment. Under standard, unamended, equitable principles, that specific risk is generally held by the employer, the developer, or the government.
Why? Because the contractor didn't design the site, they don't own the land, and they couldn't reasonably foresee the granite based on the provided survey.
Exactly. So the contractor gets an extension of time and is paid the extra money required to drill through the rock.
And how does that benefit the employer? It sounds like they are just writing a blank check.
It benefits them economically during the bidding phase. If standard rules apply, the contractor doesn't have to price the unknown risk of granite into their initial bid. They bid based on the SOIR. It keeps tender prices reasonable and competitive.
Ah, I see.
Right. If the employer instead forced the contractor to take all the unknown ground risk, a smart contractor would have to add a massive 20% or 30% contingency fee to their bid just in case they hit rock. The employer would be paying a massive premium for a risk that might not even exist. Balanced risk allocation creates economic efficiency.
That sounds perfectly logical. It sounds fair. But looking at the empirical studies on root causes of delays in the GCC and other hyperactive markets, that is not the reality on the ground at all, is it? The standard forms are being completely subverted.
They are being gutted. In practice, across many international markets, but highly visible in state-sponsored megaprojects, these standard equitable forms are almost never adopted in their pure state. A standard contract consists of two main parts: the general conditions, which are the balanced rules we just discussed, and the particular conditions, which are originally intended to be minor, project-specific tweaks filling in the names, the dates, the specific local laws.
But the data shows the particular conditions have mutated into something entirely different.
Completely different. Employers, particularly massive government entities and sovereign wealth funds, alongside their aggressive legal advisors, are using the particular conditions to systematically delete, revise, and overwrite the balanced general conditions. They are transforming these equitable frameworks into heavily biased, employer-driven agreements. They use bespoke drafting to transfer virtually all commercial, legal, and operational risk, even risks the contractor cannot possibly control entirely onto the contractor's shoulders.
I look at this practice like a contractual Trojan horse. It is brilliant, but it's brutal. On the cover of the massive binder, it proudly says, Standard Red Book. The contractor's board of directors looks at it and thinks, okay, standard international rules, we know how this works, we are protected by balanced risk. But when the project managers actually open the binder, they realize the bespoke particular conditions have hollowed out the inside. It looks fair on the outside, but it operates as a sophisticated trap.
That is a very accurate way to put it.
Why is this happening? If balanced risk is economically efficient, why are employers paying law firms millions of dollars to destroy that balance?
It comes down to the extreme psychology of commercial pressures and the political optics of mega projects. There are three main drivers. First, aggressive delivery programs. When you are building a multi-billion-dollar airport or a high-speed rail network, there is immense political pressure. Politicians want absolute certainty on the completion date for a ribbon-cutting ceremony, and finance ministries want absolute certainty on the budget.
Which is impossible in construction.
Right, but they try to achieve this impossible certainty by legally forcing the contractor to guarantee the date and the price, regardless of what real-world chaos occurs.
Right.
They try to legislate away the inherent complexity of construction.
They want a fixed price for an unfixed reality.
Exactly. Second is the dominance of public sector procurement. When the client is a sovereign state, they possess immense, disproportionate negotiating power. They dictate the terms on a take-it-or-leave-it basis. And third, which is the crucial enabler of all this risk-dumping, intense market competition.
Because everyone wants these big jobs.
Right. Despite the boom, there is a global oversupply of massive Tier 1 contractors competing for these prestige projects. Contractors have virtually zero leverage to negotiate the terms. If a contractor's legal team pushes back and says, this bespoke amendment transferring all ground risk is unfair, the employer will simply say, thank you for your time. We will give this billion-dollar contract to your competitor who is waiting in the lobby.
So contractors are knowingly signing fundamentally bad, highly dangerous contracts just to keep their massive revenue engines running. It's a terrifying game of musical chairs with liability, and nobody wants to be left without a project when the music stops.
That's the reality of the market.
Let's open up that Trojan horse. We need to dissect exactly what these aggressive risk transfer mechanisms look like in practice for the quantity surveyors, the contract managers, and the engineers who are actually fighting in the trenches. What are the specific traps?
The most common and arguably the most devastating weapon used in these amended contracts is the notice provision as a condition precedent.
We need to unpack that legal term. What exactly is a condition precedent in this context?
A condition precedent is a strict legal hurdle. It dictates that a specific event or action must take place before a right or obligation is created. In the context of a construction claim, it works like this. Let's say the contractor encounters a massive delay. The employer's design team is a month late delivering the structural blueprints. Under standard rules, the contractor is substantively entitled to an extension of time, an EOT, and additional costs for keeping their workforce idle. It is 100% the employer's fault.
Right, clear cut.
However, the bespoke amended contract will have a heavily bolded clause that says the contractor must submit a formal, detailed written notice of this specific delay within 14 days of when they became aware of the event. Failure to submit this notice strictly within 14 days results in the automatic, absolute, and irrevocable loss of any entitlement to an extension of time or additional payment.
Oh, wow.
The procedural notice is the condition precedent to getting the substantive relief.
So let me get this straight. Even if everyone on site knows the design team is late, even if it is undeniably, objectively, 100% the employer's fault that the project is halted, if the contractor is busy trying to fix the problem and files the formal paperwork on day 15 instead of day 14, they lose everything. They have to absorb the delay, pay their idle workers out of pocket, and then eventually pay massive delay penalties to the employer at the end of the project for being late.
Yes. Procedural noncompliance completely and ruthlessly overrides substantive entitlement. And to understand why this is so devastating, you have to look at the operational reality of how mega projects actually function.
Paint that picture for us.
Picture a site in the Middle East. It is 115 degrees, there are 10,000 workers on site, supply chains are breaking down, the project director is screaming to prioritize physical progress, to just pour the concrete. In that chaotic environment, the commercial manager is sitting in a hot trailer trying to draft flawless legal notices. Furthermore, the data shows that instructions are constantly given verbally on-site to save time.
Right, people are just talking.
Exactly. An employer's representative might walk up to a foreman and say, "Hey, this soil looks unstable. Shift that retaining wall 2 meters to the left." The contractor does it to be helpful, to keep the project moving. It costs an extra $100,000 in labor and materials, but they forget to file the formal 14-day notice of a variation because they were focused on the engineering problem.
And 6 months later, when the contractor finally submits the invoice for moving that wall, the employer's commercial team simply points to the bespoke contract clause and says, "We never received a formal notice. We are not paying you."
Exactly. Legitimate, hard-earned claims are lost purely to procedural technicalities. It instantly destroys any collaborative atmosphere on site. The contractor realizes that being helpful is a liability, and they must weaponize their paperwork from day one. Every verbal instruction is met with a demand for written confirmation. The project slows to a crawl under administrative burden.
It's an environment of total distrust. What is the next mechanism of imbalance they use?
The broad expansion of employer discretion, which effectively results in the elimination of the independent administrator.
Let's look at the standard form first. What role is the independent administrator, often called the engineer, supposed to play?
In a pure, unamended standard contract, the engineer is a highly defined, crucial role. They are hired and paid by the employer, yes, but the contract strictly mandates that they must act as an independent, neutral, professional administrator. If there is a dispute over a delay claim, the engineer is supposed to look at it objectively. They evaluate the facts, they read the contract, and they make a fair, impartial determination, regardless of whether it costs their boss money.
So they are the referee on the field. They are the first line of defense against disputes escalating to a full-blown arbitration.
Exactly.
But the bespoke amendments change that dynamic entirely.
They destroy it. In the heavily amended contracts we are seeing, the particular conditions systematically strip the engineer of this independence. They are effectively transformed from a neutral referee into an embedded agent of the employer. Their discretionary approval procedures are vastly expanded. They are given broad, undefined rights to reject claims unilaterally.
So they can just say no for any reason.
Pretty much. And more insidiously, the employer will often insert a hidden clause stating that the engineer simply has no authority to grant an extension of time or approve extra money without the employer's prior written consent.
Which means the referee is now wearing the opposing team's jersey and secretly taking orders from their coach through an earpiece. There is no neutral administration. It is just unilateral employer control dressed up as project management.
And it leads directly to catastrophic disputes. Contractors lose all faith in the day-to-day administration of the contract. They realize the engineer will never rule in their favor. So every single rejected claim, no matter how small, becomes a festering wound that is logged, categorized, and saved for the inevitable arbitration at the end of the project.
The sources also detail several examples of what they call risk transfer without compensation. These are specific, brutal clauses that just dump liability onto the contractor. Let's run through a few of these because they highlight how unbalanced this gets.
Sure. We mentioned unforeseen ground conditions earlier. The bespoke amendments will often flip the equitable position entirely. The clause will explicitly state the contractor accepts total and absolute responsibility for all ground conditions, whether foreseen, unforeseen, or unforeseeable, and shall not be entitled to any additional time or financial compensation regardless of the subsurface conditions encountered.
So if they are digging a foundation and uncover a completely undocumented ancient archaeological site or a toxic waste dump buried decades ago, the contractor just has to deal with the multi-million-dollar remediation on their own dime. That is wild. What else?
They impose extensive fitness for purpose obligations. In a normal design-build contract, a contractor agrees to build according to the provided designs using reasonable skill and care. But bespoke amendments force the contractor to explicitly guarantee that the final facility will be entirely fit for its intended purpose.
Why is that a trap?
It is incredibly dangerous. If the employer's own original conceptual design was fundamentally flawed, say they designed a power plant to run on a specific grade of coal that is no longer available and the plant doesn't work optimally, the contractor can be held entirely liable because they guaranteed the ultimate purpose of the facility, regardless of who made the design error.
I think of that like being hired as a baker. The client gives you a very specific recipe for a cake. You follow the recipe exactly, but it turns out the client wrote down salt instead of sugar. When they eat the cake and it tastes terrible, they sue you because the cake isn't fit for the purpose of being a delicious dessert, even though it was their recipe.
That is a brilliant analogy, and it happens on billion-dollar scales. They also routinely employ uncapped liquidated damages. Normally, if a contractor is late, they pay a pre-agreed daily penalty, but it is capped, say, at 10% of the total contract value, so a delay doesn't completely bankrupt the company.
Let me guess, the amendments remove the cap.
Often they remove it entirely, exposing the contractor to infinite liability. And finally, they aggressively exclude price escalation claims. Imagine signing a 5-year infrastructure contract. In year 3, a global supply chain crisis hits, and the price of structural steel triples. Standard contracts often include a mathematical formula to adjust the payment to reflect extreme macroeconomic inflation.
And the bespoke particular conditions simply delete the escalation formula.
Completely. The price is locked in stone. The contractor is forced to absorb 100% of the macroeconomic inflation risk.
If we step back and connect this to the bigger picture of the global economy, what is the cascading effect of all this? Contractors aren't charities. They have thin profit margins. They can't just absorb infinite risk and multi-million-dollar losses. Where does the pressure go?
The cascading effect is incredibly toxic to the industry. The Tier 1 main contractor is squeezed by immense cash flow pressures from the employer above them. So what is their survival strategy? They take all of these harsh terms, these strict 14-day notice traps, these uncompensated risks, and they force them down the supply chain. They create what are called back-to-back subcontracts.
Ah, I see. It's a game of hot potato with liability, and the smallest guys are left holding the potato when the music stops. The main contractor tells the electrical subcontractor, the employer only gives us 14 days to file a notice. Therefore, you only get 7 days to notify us. And if the employer doesn't pay us for the steel inflation, we don't pay you for the copper inflation.
Exactly. They pass the pain downhill. And the massive electrical subcontractor passes it to the smaller subcontractors and down to the material suppliers. You end up with a highly fragile, deeply distressed commercial ecosystem. It is built entirely on shifting catastrophic risk to the smaller entities who are least capable of managing it, legally defending it, or financially surviving it.
It sounds like a house of cards.
It creates a combative, dispute-prone environment where everyone is just trying to survive the contractual traps set by the entity above them.
Which brings us to the ultimate clash. The contractor is pushed into a corner, they've lost millions, they've finally reached the breaking point, they say enough, and they take the dispute to an international arbitral tribunal. We've talked about the sword the employers are using, these ironclad, heavily biased, bespoke conditions. But what defense does the contractor have? How do they fight back against a contract that their own executives willingly signed?
To understand the contractor's shield, we have to deeply examine the legal environment of the specific jurisdictions we are talking about. Let's maintain our focus on regions like the GCC. These states, the UAE, Saudi Arabia, Qatar, do not operate under the English common law systems that you might find in London, New York, or Sydney.
And that distinction is vital. Common law systems are generally known for strict, literal textualism. Freedom of contract is paramount. If two massive corporations sign a contract that says you lose your right to payment if you miss a 14-day notice, a common law judge will likely look at it and say, tough luck. You are sophisticated commercial parties. You signed it, you take the hit. A deal is a deal.
Exactly. Common law heavily prioritizes certainty over fairness in commercial dealings. But the GCC jurisdictions operate under civil law systems, and crucially, these specific civil codes are deeply rooted in and heavily influenced by Islamic jurisprudence or Sharia law.
That's a huge shift.
It creates a massive fundamental shift in how contracts are interpreted, because while the contracts themselves are drafted by international law firms in a very aggressive common law style using English templates, they are ultimately subject to the overarching mandatory principles of the local civil law.
It is a profound clash of legal cultures. You have common law drafting colliding with civil law principles. What are these overarching civil law principles that an arbitral tribunal is legally mandated to apply?
The most vital foundational principle in these civil codes is good faith. Parties must perform the contract in good faith. You cannot maliciously trap your partner. Furthermore, Islamic jurisprudence heavily emphasizes principles of equity, fairness, the strict prohibition of the abuse of rights, and the absolute prevention of unjust enrichment.
The tension there is unbelievable. You have a bespoke contract drafted by aggressive lawyers that explicitly says the employer can unilaterally reject any valid claim for any reason and can enrich themselves by taking free work if a notice is 1 day late. And sitting directly above that contract is a mandatory national civil code that says you must act in good faith, you cannot abuse your contractual rights, and you cannot unjustly enrich yourself at another's expense.
It creates a fascinating, highly complex battleground for the arbitrators. Because the UAE Civil Code, for example, explicitly prioritizes fairness and equitable conduct over strict literal interpretation if the literal interpretation leads to an overtly abusive or unjust outcome. The contract is not the absolute king, the law is.
And this brings us to the most crucial legal doctrine we need to discuss. The ultimate shield for the contractor, the doctrine of contra proferentum. Let's dive deep into this. What exactly does this mean, and how does a tribunal actually use it?
Contra proferentum is a Latin term that translates roughly to against the offerer. It is a fundamental principle of contractual interpretation. It dictates that where a contractual provision is genuinely ambiguous or reasonably capable of more than one interpretation, that ambiguity shall be interpreted against the party that drafted or imposed the clause.
So because the employers and their high-priced legal teams are the ones aggressively writing all these bespoke, one-sided particular conditions, if they make a drafting mistake and write something confusing, the tribunal will automatically assume the interpretation that favors the contractor. Since the employer controls the pen, they must bear the ultimate risk of ambiguity.
Precisely. It emerged as an equitable doctrine to prevent stronger parties with unequal bargaining power from benefiting from their own unclear or contradictory drafting.
But I want to be very clear here, because I think a lot of commercial managers get this wrong. If a contract is incredibly unfair and one-sided, can a contractor just walk into an arbitration hearing, yell contra proferentum, like it's a magic spell, and instantly get out of the bad clauses? Is it a get-out-of-jail-free card for signing a terrible deal?
No, absolutely not. And that is the most dangerous misconception in the industry. Contra proferentum is explicitly a secondary or last resort principle of interpretation. Arbitral tribunals do not start their analysis with it.
Okay, walk me through the step-by-step process.
Yep.
How does a tribunal actually evaluate a disputed clause? What do they start with?
The tribunal must first exhaust all primary rules of interpretation. Step 1. They examine the plain, ordinary wording of the clause. If the clause clearly and unambiguously says 14 days, they cannot just ignore it because it feels unfair. Step 2. They look at the clause in the context of the entire contract. Does another clause clarify it?
Okay, and then?
Step 3. They look at the commercial purpose of the project. What were the parties practically trying to achieve? Step 4. They look at industry practice and the mandatory civil law principles of good faith.
So it's a very rigorous process.
Very. Only if, after all that exhaustive analysis, a genuine, irresolvable ambiguity remains. Meaning the clause could honestly mean two different things. Will the tribunal pull out the shield of contra proferentum to break the tie against the drafter?
But if these employers are hiring top-tier international law firms to write these amendments, shouldn't the drafting be airtight? Why would there be genuine ambiguities in a billion-dollar contract?
Because of the chaotic reality of how these contracts are actually assembled, the data refers to it as repetitive drafting practices, or more simply, cut-and-paste drafting. Employers and their lawyers often take a set of highly aggressive, bespoke amendments that they developed for a railway project 10 years ago, and they just copy-paste them into a new contract for a hospital today without properly tailoring them or checking how they interact with the new baseline document. They create a legal Frankenstein's monster.
And when you start aggressively deleting core clauses from a highly integrated, carefully balanced document like the standard FIDIC Red Book, and blindly pasting in paragraphs from older projects, the internal logic of the document shatters.
Exactly. You inevitably create massive contradictions. The data notes this is particularly relevant in high-stakes disputes involving variations, indemnities, and the precedence of documents. Let's look at a hypothetical. The standard general conditions state that the engineer has the authority to value variations extra work. But a newly pasted bespoke clause in the particular conditions says that only the employer's executive steering committee can legally approve variations.
So they contradict each other.
Right. During the project, the engineer orders extra work. The contractor does it. The employer refuses to pay, saying the steering committee didn't approve it. That is a genuine, massive ambiguity created entirely by sloppy, aggressive drafting. Who actually has the authority? The contract says both.
Yeah, that is exactly where the contractor raises the shield. The tribunal looks at it and says, employer, you drafted this Frankenstein document. It is inherently contradictory. We cannot resolve the ambiguity through primary analysis. Therefore, under contra proferentum, we are going to adopt the interpretation that favors the contractor, and we rule that the engineer's instruction was valid. Pay the contractor.
It acts as a powerful equalizer when the drafting overreaches and trips over its own complexity. And when you combine contra proferentum with the overarching civil law principles of good faith and unjust enrichment, you can see how an arbitral tribunal in the GCC might decline to enforce excessively one-sided procedural technicalities.
Let's go back to our 14-day notice trap.
Yeah.
If the employer's design team causes a massive 6-month delay, and the employer then tries to use the fact that the notice was filed on day 15 to avoid paying millions of dollars, the tribunal can use civil law principles to block them. They can say no. Enforcing that procedural technicality would result in you being unjustly enriched by your own massive failure. That is an abuse of rights under the civil code.
Precisely. The shield holds. But it requires an incredibly sophisticated legal team to weave together the facts, the contract ambiguities, and the local civil jurisprudence to wield it effectively.
Which brings us to the ultimate takeaway for the professionals listening right now. We have traversed the entire life cycle of risk. We've looked at the New York Convention that guarantees the final ruling can be enforced globally. We've looked at how equitable standard forms are weaponized into bespoke traps. And we've looked at how complex legal doctrines are used to fight back. But what is the actual day-to-day strategy? Because the commercial reality is that despite these risks, contractors are still going to sign these terrible contracts tomorrow morning. The market oversupply and the desperate need for revenue aren't going away.
The core strategy has to shift fundamentally. You cannot rely on winning an arbitration. Arbitration is a failure state. Even if you have the shield of contra proferentum, an international arbitration takes years, costs millions of dollars, and destroys business relationships. The strategy must shift to aggressive, proactive project management.
Right. Relying on an arbitrator to save you with a nuanced civil law interpretation half a decade after the project is finished is a terrible business model. So what do the project directors and commercial managers actually need to do on Monday morning?
First, they must identify the traps during the tender phase. Don't wait for the dispute to crystallize. When you are reviewing the bespoke particular conditions, actively hunt for contradictory language. If you see an ambiguity, raise a formal clarification during the bidding phase. Force the employer to clarify it on the record before you sign.
Catch it early.
Exactly. Second, and most importantly, you have to build a formidable project control system. You have to play the administrative game better than they do.
What does that look like on a massive site?
It requires investment in technology and personnel. If the bespoke contract demands a highly detailed notice within 14 days, you don't rely on an overworked engineer to remember to send an email. You build a dedicated claims team. You utilize advanced project management software that cross-references daily site logs with the complex project schedule. You institute mandatory daily stand-up meetings where the sole focus is identifying potential delays instantly. You ensure that the 14-day notice goes out flawlessly on day 2.
So you fight paperwork with better paperwork.
You have to. You do not let poor correspondence management be the reason you lose a legitimate multi-million-dollar claim. You have to treat the administrative paperwork with the exact same rigor and seriousness that you treat pouring the structural foundation.
But looking at the broader industry, is there any hope for systemic change? Or are we just locked in an arms race where contracts get more and more aggressive and project control systems get more and more expensive until the entire industry snaps? What is the future outlook for global mega projects?
There are actually some very positive systemic indicators on the horizon. And ironically, the push for fairness isn't coming from the contractors, it is coming from the top down. Major international lenders, the massive global banks that actually finance these multi-billion-dollar mega projects, and multinational institutional investors are starting to realize that risk dumping is a terrible investment strategy.
Wait, why do the banks care? They are just providing the capital. They aren't the ones pouring concrete or fighting over delay notices.
Because risk dumping creates an incredibly brittle project. The bankers have realized that if you force all the unknown project risk onto a contractor who mathematically does not have the balance sheet to bear it, you haven't actually transferred the risk, you've just hidden it.
Wow, that's profound.
It's true. When a massive unforeseen event happens, say, the tunneling machine hits the granite, and the bespoke contract says the contractor must pay the $50 million to fix it. The contractor doesn't magically find the money, they go bankrupt, they fold, they walk off the site. And then the bank is left holding a half-finished billion-dollar concrete skeleton in the desert that is generating zero revenue, embroiled in years of litigation. The illusion of transferring risk to the contractor actually transferred the ultimate risk of project failure directly back to the investor.
That makes perfect sense. The realization that a fundamentally unfair contract physically threatens the financial viability of the investment.